in the cloud. All right. And then I'll give some preliminary instructions and introductions. Okay, it's 1 minute after. Well, good afternoon, everybody. It is January 6th, 2022. So actually 1 year ago today, our democracy was being challenged at the Capitol. And a year later, here we are talking about how we defend parents' constitutional rights. I think it's actually pretty interesting timing of today's webinar, which was, I guess, coincidental. But I have with me today two fabulous attorneys, and a lot of you probably already know them. First, I have Trish Haas, who is a family law appellate attorney, and she also does trial work in Grosse Pointe at the firm of Haas and Prokopec. And I've known Trish for a long time. We've been co-counsel, we've been opposing counsel, we've worked on committees together, we've co-presented for ICL. So Trish is a great attorney, and more recently is quote unquote famous for being the mother's attorney in the OBrien versus Denuncia case, which I suspect we'll be talking about a little bit today in a little bit. The other guest we have today is Josh Pease. He is a family law and child welfare attorney in Lansing at the Kronzik Law Firm. And Josh is a council member for both the children's law section and the family law section for the state bars of Michigan. So he really has that perspective of the representing parents against other parents in custody cases, but also representing parents in child welfare proceedings when the state is the actor that they're going against. So welcome, Josh and Trish. We're happy to have you here today.
Thanks for having us today, Lisa.
So just a few reminders for the audience, and I know people are still coming in, but we have a chat function down at the bottom and a Q&A function. So the chat, I think everybody can see. The Q&A may only go to a limited group of people, but if you have a question or comment, feel free to put it in the Q&A or put it in the chat. I'm going to be trying to monitor both. We have a lot of ground to cover today with so many potential areas of where due process and other constitutional rights can be violated when we're representing parents in family law and child welfare cases. So, you know, I'm not 100% sure we're going to get through everything that Trish, Josh, and I have already talked about, like being important issues to discuss, but we're going to do our very best. So starting off, so the first part we're going to talk about just really quickly what types of constitutional rights are at stake in our cases. And then we're going to do a little bit of a deeper dive, particularly into due process, because that's where we are seeing a lot of the action in the court cases and when we're representing our clients. And then the last thing we're going to get into, and I'm not sure how much time we're going to have for this, we're going to make sure we have a little bit of time at the end to talk about how to help you raise these constitutional issues when you're in court. So we're just going to have like an engaging, hopefully, conversation with Josh and Trish. They can interrupt me anytime they want. I'll start off. I'll just name the first one. There's a lot of constitutional rights that are implicated when you represent parents, whether it's in a custody case or in a child welfare proceeding. And for family law, I think the big case that a lot of us have heard of is Troxel versus Granville from the United States Supreme Court in 2000. And that's the case that confirms that parents have a liberty interest in the care, custody, and control of their children. So it's a case that I cite all the time in my custody cases, particularly when I feel that the court violating the law is violating my parents' constitutional rights to their liberty interest. Josh and Trish, feel free to add anything you want to other different constitutional rights at stake.
Well, certainly in child welfare proceedings, there are some pretty significant constitutional rights because it is the state attempting to deprive parents of a fundamental liberty interest. The right to counsel attaches, so the Sixth Amendment. And of course, there's also the right to effective assistance of counsel. You don't just have a right to an attorney, but you have the right to have an effective attorney. So the same provisions from Strickland v. Washington apply regarding effective assistance, and on appeal, there's always the opportunity for a Ginther hearing to expand the record if there's concerns that the record doesn't reflect that.
I wanted to point out with this right to counsel idea, because it is only for child welfare cases, I cannot tell you how many times I have potential clients call me and complain that or think that the judge should appoint an attorney for them in a custody case. And that's just not how it works in family law. You only have that right to attorney in a child welfare case because your rights can be terminated in the context of that case. So I just wanted to point that out. I mean, I know the attorneys know that, but it's like really a huge misconception on the part of the community that they think that they should have an attorney appointed to them by the court, even in the context of custody litigation.
We also know that, at least to an extent, the Fifth Amendment right against self-incrimination applies in child welfare cases. Because there's civil proceedings, it's not as much a blanket rule as in criminal cases, but we had a case, actually, I think it was one of Lisa's cases just a few years ago in Ray Blakeman, where the court tried to coerce a parent into waiving their Fifth Amendment right to remain silent and incriminating themselves criminally by saying, we're not going to return your children to your care until you do so. And thankfully, the Court of Appeals said, no, you can't do that. The court cannot coerce a parent into waiving that right. We know that religious liberty interests attach in child welfare cases. We've had, I think it's 3 different opinions in the Pyland matter now regarding Michigan's statutory framework for allowing parents to make medical decisions for their children, and those medical decisions not necessarily being construed as abuse. So we know for sure that a number of our fundamental constitutional rights do apply to child welfare cases. There's some that are a little more questionable. I'm not aware of any Michigan case law saying the Fourth Amendment applies to those cases, but I believe that there's 1 or 2 federal cases regarding that. So definitely constitutional rights apply to child welfare cases, without a doubt.
And then adding to your comment about the religious liberty interest, like in Pyland, I think that could also come up in the context of a family law decision with the vaccination cases that we're facing, and also those happen in child welfare cases as well. I already mentioned due process, and really just want to point out that due process is not only a notice and opportunity to be heard. So like if in child welfare cases, there's sometimes issues where the parent didn't get notice about a proceeding and didn't get to participate, that's a due process violation because they didn't have a notice and opportunity to be heard. And I suppose that type of due process issue could come up in any kind of case, but the one that really comes up a lot in the family law context is how due process is applied to the liberty interest of parents. So I want us to move on, because I know we have a lot to talk about with the substantive nature of these issues. I want to jump into all the different ways, and we brainstormed and came up with a bunch of ways. And I think people in the audience are going to be like, well, what about these other 10 ways that you didn't mention? Well, that's fine too. Send us a note, because we'll want to consider them down the road if we can't get to them today. But parents' due process rights are violated in a lot of ways. And I want Trish first. She had a quote, and I was going to say it, but I think I'd rather you say it, Trish, because it was your quote about family law and due process. And then also, if you don't mind, just tell us a little bit about the OBrien case and the due process issue that arose in that case.
Well, I think I've just noticed personally over the last 10 years that there's been a real degradation in the rights of parents in custody cases. It seems that courts forget that parents do in fact have a liberty interest in their children. And when we're talking about entering custody orders or even a parenting time order that terminates contact with one parent without an evidentiary hearing, we're most certainly talking about implicating one's rights to parent their child to maintain that liberty interest. And unfortunately, in OBrien versus Denuncia, it's unfortunate the case had to go all the way to the Michigan Supreme Court. But essentially what had occurred is there was a parenting time order that was entered after a motion hearing that completely suspended all of my client's rights to parenting time. And at that point in time, there wasn't even a hearing scheduled for the future. There was no evidence considered. There was no findings made by the trial court. There was just nobody followed any of the provisions of the Child Custody Act. And of course, when you're faced with I was not the attorney of record at the time the order was entered. So one of the first things I like to do is look at what can we do. And in this particular case, I tried to notify the trial court that it had a duty and obligation to conduct an evidentiary hearing and actually consider evidence and make findings before it entered such an order. Now, ultimately, the trial court did give me an evidentiary hearing, but it continued its improperly entered orders throughout the entire case. And really what happened is we had a family that was destroyed, for lack of a better word, because we had parents my clients had no contact with her children for years and years. And even though we won the battle, perhaps by getting an order of reversal from the Michigan Supreme Court, that was 3 years later. So the damage can't be undone by the Michigan Supreme Court's order. So it's so important that whenever you're a family law attorney and you're facing entry of an order like this, that you really think of the long-term impact such an improperly entered order can have, and try to address the due process issues right then and there to the best of your ability.
I want to point out, if the folks here are interested in the OBrien Denuncia versus Denuncia case, if they're interested in using it when they're maybe writing trial court briefs or even appeal briefs, I would highly, highly recommend you read Judge Gleischer's dissenting opinion. It's one of my favorites out of many favorite Judge Gleischer dissenting opinions. Read the Supreme Court order, which is fairly short. A lot of you know that I recently published a book about children's rights in custody cases and how they're harmed. In the book, I talk about the OBrien case multiple times. I talk about it in the introduction. I talk about it in chapter 1 that has to do with due process. I talk about it in chapter 3 that has to do with post-judgment custody. So even though I didn't work on the case at all, this is Trish's baby, and she worked really, really hard on it. I think the whole thing, I mean, it's a travesty. And certainly lots of violations, but it's like very interesting from a legal academic perspective about all the things that went wrong and how the courts were later trying to fix what went wrong in the trial court. So thank you for sharing that, and thank you for keeping up the fight, really, because it was a long battle. And I did some math a while ago, and the math that I came up with from the time of that interim order that was entered without any evidence or findings until the Supreme Court finally vacated that decision was 43 months.
Yes, it's been very painful. And, we have children who are going to turn 18 here in the next couple of months. And it's really unfortunate because despite all of the hard work, and I'd like to commend the family law section for the work they did on this matter as well with their amicus briefs. It's just really unfortunate that the damage, we were unable to undo the damage that has occurred during that long period of time when children had no contact with a parent. And most certainly my clients' liberty interests were affected. But I think we've seen a trend where trial courts look at who's the better parent, not recognizing that you can physically remove a parent, but you can't biologically remove that parent. And that child always has a biological, always is biologically connected to that parent. And I think trial courts need to be a little more aware of that and understand that this does have longstanding implications. And taking it to the Michigan Supreme Court isn't really the way it should have been handled.
Right. I want to turn to something that did come up on OBrien, but it comes up in a lot of other cases, and maybe Josh can talk a little bit with us about it, about the delays in proceedings. And the reason I'm pointing to Josh is because to compare child welfare proceedings with family law cases and the court rules that govern both areas, can you talk, Josh, just a little bit about what types of procedures are in place to make things happen quickly in child welfare cases? And we can talk about the delay that's happening in the three of us can talk about the delay that's happening in family law cases, again, contrary to what the court rules say. Go ahead, Josh.
Sure. So there are extremely strict timelines in child welfare cases, unlike any other type of case that I'm aware of. If the court signs an emergency order to remove a child, there must be a preliminary hearing within 24 hours. There's the right to trial within 63 days. If a petition is filed to terminate parental rights and that petition is authorized, there's the right to trial within 42 days. But
did those things happen in those time periods?
Yes and no. Some courts are very good about strictly enforcing that, even if it means rearranging their entire docket to make it happen. Some courts are great about that. Other courts look at it and say, I can't fit this in this time period. I'm going to find good cause to push it out because I can't rearrange my docket. And obviously different courts are going to be able to handle that differently. Courts in smaller, more rural counties where they've got lighter dockets are going to be able to fit it in within the time period better than, say, Wayne or Oakland County with those incredibly heavy dockets. Bigger one, though, is review hearings. That's kind of a set in stone. It must be every 90 days. And there's really not an exception to that. And the courts have found that, yeah, you have to do it within the 90 days unless there's some extenuating circumstances. COVID provided some extenuating circumstances, and there was a published opinion in 2021. I can't remember which one it was off the top of my head, but it did say because of COVID and the court extending the timelines for review hearings, that's okay. But that was really just because you have an executive order and you have a global pandemic. That was considered good cause, but just docket management issues, generally not considered good cause to extend the timelines on those review hearings, because you are talking about children being away from their parents and the state having a continuous deprivation of that parental right.
And in child welfare cases, contrary to family law cases, in child welfare cases, the children are not with a parent at all. They're maybe with a family member, but possibly with strangers who are a foster family, versus in the family law context, for better or for worse, they're with the other parent in most cases. And maybe that's part of the reason why those timelines are more readily observed in child welfare cases. Now, for people in the audience who, like today, he just mentioned a case, couldn't remember the name, that's totally normal. But we will be circulating takeaways after today. It will probably be sometime next week, and we'll be sure to have that case with the site in it for you, so that if you're interested in following up on that particular case, we'll be able to share that information with you.
I just remembered, it was In Re S.J. Sanborn, S-A-N-B-O-R.
Oh yeah.
That sounds familiar.
Yeah, it does. I'm sure I read it. So anyway, so delay, and just to point out for family law, the delay in the proceeding is a court rule that governs the time for proceedings in custody cases. It says that a hearing on a matter has to be within 56 days from the time the hearing, like when there's a filing, what's the language? After the filing of a notice that a custody hearing is requested. So if you have an initial motion to change custody, you're requesting a custody hearing, you're supposed to have that hearing in 56 days. And then once the hearing is held, the judge is supposed to make its decision within 28 days, must enter a decision, not just like put it on the, like, I think that means an order. Now, I don't very often see any of those guidelines being followed. Trish or Josh, do you have any comments about that?
Well, I would say that routinely those guidelines are not followed across the board. I'm not sure if maybe you're aware, Lisa, that even in Wayne County, it's taking 90 days just to get a case filed right now. So most certainly, if you request a hearing, you're not going to get it within 56 days from the date of filing.
It's funny because I was looking up some things in Wayne County yesterday and today, and a motion that was filed. Well, right now they're docketing motions that were filed like in late October. So they're just getting them on the docket. I'm not talking about having them heard. I'm not having them looked at by a judge, but just getting on the register of actions that the court is aware that this document exists. And they're so they're 3 months behind right now. And I'm assuming it's because of, you know, employees not being able to come to work. Maybe they have quit, you know, whatever. I'm assuming it's shortages of staff, but I don't know. And I know because they have the biggest docket in the state of Michigan. So it's going to impact things that impact small counties are going to impact them even more so. So let's talk a little bit about the friend of court processes, because I know we have a lot of different issues that come up with as far as constitutional violations in the context of friend of court proceedings. And either one of you that wants to jump in and talk about one of them. But one thing we talked about the other day was the FIGC process that began just 2 years ago. The facilitative facilitative information gathering conference. Did I say it right?
Yes.
And you can go to that FIGC conference and have the FIGC investigator, who's not an attorney, make a recommendation. And there's a way to get out of that process as well. Make a recommendation that even if you object to it, it can become an order of the court. I think while the objection is pending. Have either of you had challenges to that, or had problems that have arisen in your cases because of that?
Well, I'll say in mid-Michigan, that is the procedure we use. Ingham, Eaton, Clinton counties, the case gets referred to friend of the court for a FIGC with an investigator, and the investigator afterwards will draft an order, it'll get signed by the judge, and that's your interim order. You've got a custody, parenting time, child support order before you've ever set foot in a courtroom. And not necessarily, you know, hey, I need an ex parte order because of the imminent risk of harm. I mean, you've got a non-attorney doing an investigation and giving their opinion, often without even referencing the established custodial environment or the best interest factors. Sometimes they do, sometimes not. But again, that is entered as the temporary order. It's a party's obligation to object to it, but that remains the order until a judge signs an order vacating it or saying something else. So that is often a concern. I feel like we've been very lucky in mid-Michigan to have some good investigators who I can't say I've had a ton of big C's where I felt like they were completely out of left field off base, but it does happen. And unfortunately, knowing that the established custodial environment is, you know, a factual thing, it's about what actually is the child's environment, not what should it have been if the court had gotten the order right.
Or how it got there.
Right. So you're having these investigators effectively creating or even changing the established custodial environment through these temporary orders. And that can have long-term impact on what happens through the rest of the case.
So Trish, you're in East Michigan. So is the process differently in the courts that you're practicing? And I'm assuming you're a lot of times in Wayne and Oakland, Macomb, Washtenaw type courts.
Yes. Well, I would say really in Macomb, I really don't see that process, the new court rule being implemented. You know, Oakland County and Wayne County has been so far behind that with cases that they don't utilize the front of the court in the way some of the other counties do. So I can't say that process really has been implemented in Wayne. You know, Oakland, it's been pretty standard procedure that even on a motion hearing date that you go and meet with a front of the court counselor or a referee, and they make a recommendation to the judge. A lot of times parties aren't a part of that process, which I've always had a hard time with. And then that recommendation somehow can become an order of the court, again, without findings. So maybe perhaps they're not using the court rule in the way that the mid-central counties are using it. But I think the result is the same, that we have a brief hearing that's not even recorded. There's no record of these hearings on Wednesday mornings, and then they become the basis of a court order. And it's really unfortunate, because I did actually have a front of the court counselor in Oakland County indicate to me that my client didn't have any due process rights or didn't have any constitutional rights or liberty interest, that only the child did. So this is the kind of thing that I've been seeing. It's just really a degradation of the constitutional right to parent their children. And, you know, these court rules, as they get implemented and changed, it just takes away more and more rights from parents to have an actual hearing and have evidence considered. And I guess I will parlay into MRE 1109, which allows the front of the court report to come in. And that's without regard to whether or not there may be any evidentiary objections as to hearsay or foundation, but that report gets considered under MRE 1109. All of the, and it's unfortunate, because due process requires that a litigant be afforded a fair trial of the issues involved and a determination of disputed questions of fact on basis of evidence. So evidence should be that's admitted, not just a front of the court report.
Yeah.
Admissible evidence, not just a front of the court report, but MRE 1109 is a way to completely bypass a litigant's rights to due process.
Which makes a difference when you have a friend of the court referee writing a recommendation, because they're only considering, and if they consider inadmissible evidence, that will be part of the record, because there's a recording, there's attorneys, there's the rules of evidence apply. Whereas with the investigation process, sometimes the parties aren't even in the same room. If they're, that's happened where for whatever reason they meet with them separately, you don't know what the other side's presenting. You find, you see a report that has tons of hearsay, you don't even know where it came from. And then the judge reads that report. So how is the judge being influenced by something it's seeing in a report that it should never have seen had it been in a court proceeding, even with the referee or in front of the court proper? Josh.
So first, I think, Trish, you meant 1101B9, right?
Yes. Did I misspeak? I apologize.
You said 1109.
Oh,
and I share the same concerns, although I do have a bit of a different opinion regarding whether it's a due process issue. I view that particular MRE as effectively a hearsay exception. Same way that reports generated in the normal course of business are hearsay exceptions. I'm not going to comment on whether it should be an exception or not, but that's, I think it's akin to that. And I'm not sure that hearsay exceptions would qualify as a due process issue, given the current state of the law. So I share the same concerns, but I'm not quite on the same page about that being a constitutional issue.
So another issue that when we were discussing in preparation for this webinar that we had a little bit of discussion and maybe not complete agreement on was the ability of the investigator or friend of court personnel to testify. And if they can testify, you know, what does that look like? And I'll let you both share your thoughts. And I had some additional, I'm sure I'll have some additional comments to make.
So I've certainly seen investigators come in to testify basically as fact witnesses. Here's what the parties said during the FIGC or the investigative conference. And I think there's a lot of value to that, especially if what they said on the stand doesn't match what they said in the FIGC. But I've also seen circumstances where they're asked, well, what's your opinion or what do you think should happen? And I think that should be a big no-no, because I think at that point you're asking this investigator for essentially opinion evidence, or not just opinion evidence, expert testimony. You're treating them as an expert asking for their opinion on what should happen, even though they're not a party to the case. They have no stake in the case. So I think as long as the court's keeping them as simply fact witnesses, that's perfectly within line. But once the court shifts to asking them their opinion, I think there needs to be challenges and essentially arguing, hey, judge, referee, whoever, you're now treating this person as an expert witness without going through the qualifications for them to be an expert witness.
Trish?
Well, I do routinely have the investigator testify when they issue a recommendation report. I think it's important to flesh out the basis of their recommendation. In my experience, they do survive any challenges as to whether or not they're an expert, because it's a front of the court person who was appointed to investigate a child custody dispute, and they certainly have the background necessary to make such a recommendation. My issue is when we refer a friend of the court refers a matter for a psychological evaluation. I think it's really problematic and certainly is a violation of due process rights when the attorney is not allowed to have the underlying test data that the friend of the court representative or friend of the court psychologist used when making their recommendation. Most certainly, if we're going to have a friend of the court report admitted, especially such as a psychological evaluation, the attorney should have a right to have that underlying test data so that we can properly cross-examine. Without that, it's most certainly, in my opinion, a violation of due process rights of a litigant.
So I had an interesting wrinkle in one of my cases a couple of years ago where the friend of court investigator who had investigated the case at the time of divorce, fast forward 3 years, the judge brought the investigator on to testify about, basically with conversations with the parties and whatnot. But that person also sat in the room to watch apparently parts of the trial. I'm not sure how much of the trial. And then as soon as the trial finished, the judge basically had that investigator go write up a recommendation for legal custody, presumably based on the proceedings that had just happened in front of the court, which then became an order of the court like the day after. It was just like this, like the creativeness of how rights can be violated and how the law can be twisted is just, it's really endless. I mean, how this happens in cases like, you're not going to see that again, I don't think. It's just so odd and unique. But it's just, that's the types of things that I think the three of us deal with regularly, is these very unique issues that may come up in a very twerky way, that we have to then try to explain to the judge why you're not allowed to do that. You brought up something.
You had mentioned yesterday, Lisa, that obviously in a criminal case, we would never see these type of due process violations. It's just interesting how
unheard of. Yeah,
such a degradation.
Yeah, that really ties in with what you were saying too earlier. So the comment I just made, and also you were talking about with the psych reports, really leads into this topic of the improper delegation of authority to an investigator, or let's move on to a guardian ad litem. So I've seen cases, for example, where the court's giving the guardian ad litem, sometimes it's even a therapist, the authority to make basically parenting time and custody decisions that, I mean, the parents might be able to get to object to it, but it's a non-attorney, non-judge making some sort of recommendation based on the facts that are before them in a non-court proceeding. And then if the parent doesn't like it, they have to object and go have a court hearing. In the meantime, that recommendation by this non-attorney, non-judge, non-court proceeding becomes the quote unquote order that they have to follow. And sometimes it's even signed by the judge in the temporary form while they're waiting for their hearing to happen. Do either of you have any experience with a judge delegating that kind of authority to these non-attorneys?
Well, I think it's quite common, unfortunately. And, obviously judges have a difficult job and their dockets are always overflowing. And I empathize with that. However, our judges are elected officials. There's checks and balances involved. And I see it so often that a judge will actually delegate their authority to either a guardian ad litem or a therapist. A lot of times, sometimes these recommendations that are being made are secret. They're not even known to the parties. It's ex parte communications. And again, it's really problematic because litigants, there's a reason why we have judges that are elected officials, and we shouldn't be delegating that authority to third parties such as guardian ad litems or therapists, who certainly don't have the expertise and the knowledge of the law that the judge has. So I sympathize with trying to get speedy docket resolution, but I don't think that the trend of delegating that authority to third parties is appropriate. And I will say that for me, there's a lot of guardian ad litems that probably are excellent at their job, but I try to avoid guardian ad litems because, quite frankly, I see that a lot of times appointing a guardian ad litem actually makes a case much more messy than it would have been had the judge just maintained control over the docket.
I want to talk more about guardian ad litems and LGLs, but before we move to that topic, Josh, did you have anything to add about this improper delegation of authority to the non-attorney actors in the process?
I have. I've seen cases where it's clear there's some estrangement between child and one of the parents. The child's in counseling, and the court might say parenting time is reserved or suspended until such time as the child's counselor says it should resume. It's like, well, why is the child's counselor making that decision? That is a judicial determination, especially if we're talking about suspension of parenting time where we have clear law. The statute is very clear. You need clear and convincing evidence on the record that parenting time would be harmful to the child. And we have case law saying you must have periodic reviews. So for the court to basically say, parenting, whether the parent can have parenting time at all is up to the child's therapist, is a clear violation of both the statute and the case law, in my opinion.
I mean, a periodic review helps. It's better than not having a scheduled periodic review, but it doesn't solve the delegation, the improper delegation of authority problem.
Right. I mean, to me, that's a matter of bringing that therapist into the courtroom, have them testify, so the judge can make a decision based on the information provided by the therapist, not saying the therapist gets to decide when parenting time resumes.
And I know you brought up a case that I had worked on, Regner versus Luna, which is the published case that requires periodic reviews. Now, I didn't go look it up today, but my recollection was that the children were able to decide when they were ready to have parenting time. I could be wrong. It could have been the therapist could decide based on the meetings with the children whether they were ready to have parenting time with their mother in that case, who hadn't had parenting time for a long time based on a bunch of different things that were happening in other cases. But anyway,
I think that's a good point. We do also occasionally see cases where the court will basically defer to the children.
Yeah. Okay.
Which to me is an even more egregious delegation of authority because they're not even professionals. They're kids. And their voices do need to be heard in these cases. But a court deferring to the children on whether parenting time should occur is a serious breach of due process.
Having just reviewed it today, I wanted to point out in the OBrien case where she talks about how there's a 13-year-old case who's, in battles with her mother, as a lot of teenage girls are, but there was already problems, with the mom and daughter relationship that they needed to work on. And the comment that Judge Gleicher made was what kind of the message that was being sent to the daughter by the judge suspending the mother's parenting time is a clear message to the daughter that something is terribly wrong with the mother. And then 4 years later, like we're going to expect the daughter to be able to say that, hey, I'm ready for parenting time again, if she has this belief from all these years that there's something wrong with her mother. I mean, that was just kind of the striking thing to me today, at least. Again, I've read that opinion many times. But anyway, let's talk about LGLs and GALs. And this is a really actually big issue. We probably could have a whole webinar on this topic. So I know we're not going to be able to spend as much time as we want, but I've seen a lot of cases where it's very confusing to somebody like me who's reviewing what happened from the pleadings and from the transcripts and from talking to the trial attorney or client about whether the person that's been appointed by the judge, who happens to be an attorney, has been appointed as a GAL or an LGAL. And there's very different roles that each of them have. And one of them is an advocate for their client, who happens to be a child, and they have to advocate for the best interest of the child because that's their client. And the other one is the GAL is making a recommendation to the judge about what's in the children's best interest. And there's a lot of different rules that go into place depending if you're one or the other. But what I've seen a lot of, and I would love to get feedback from both of you, is it's not clear which hat this person is wearing ever, or it changes from one day to the next, or they're appointed to be a GAL, but then the day the trial starts, they're declared to be something else. And it's like completely changing the role of a person from being somebody who's there to assist a judge to now all of a sudden they're an attorney representing a client who can no longer be put on the stand to be cross-examined, just a whole bunch of things. So any experience that you two have had with a GAL or LJL issue?
So in mid-Michigan, and I'm very thankful to do most of my family law practice in mid-Michigan, we rarely use GALs. It's very rare. I can think of one case in my 10 years of practice where we utilized a GAL on a family law case. I did experience that exact issue myself, though, on a guardianship case once where I was appointed as the GAL, and then come trial, I was one of the attorneys wanted to call me to the stand, and the judge said, no, that's the attorney for the children. So I have been in that seat myself, and I was caught off guard myself because I didn't know what my role was, apparently. I was told I was there to investigate. I did, and I was caught off guard when the court suddenly says, no, you're the advocate for the children. So I think that's something that it's not about the GAL themselves, maybe it's about the court not being clear upfront and consistent with what that attorney's role is.
And Lisa, like I said, I've really been very lucky in avoiding appointments of GALs in cases. But I will say that I did have a case on appeal, the NASR case, and I don't have the site, it's not published, but as I recall, the Court of Appeals did spend a considerable amount of time discussing the difference between a GAL and an LGAL. And in this particular case, the trial court was relying heavily on the GAL, notwithstanding the fact that these reports were not even made public or not even available to the parties. So for that basis alone, the trial court ultimately, or the Court of Appeals ultimately did reverse the trial court decision. So like I said, I don't have a lot of input on this particular matter because I try to avoid appointment of GALs, because unfortunately I know it's a measure that's intended to make it better for the parties and for the child, but it just seems that GALs can become very costly and actually make a case a lot more messy. And so that's
Now you mentioned GAL several times. I've seen LGLs appointed in family law cases, but usually they're appropriate in a child welfare case. And you see them all the time in child welfare cases, and they do act as the attorney for the child, in my experience. Josh, I don't know about yours, but it seems like there's not this confusion. The confusion, I think, is coming up in family law cases, not in child welfare cases. Do you agree with that, Josh?
Yes, and actually that is intentional. In child welfare cases, the court is obligated to appoint an LGAL for the children in every case. They can also appoint a GAL if it's necessary, but you will never, ever see a child welfare case where there is not an LGAL.
Right. Thank you for pointing out the NASR case. I'm going to look it up, but is it NASSER?
Yes.
Okay.
And it's
Definitely want to take a look at that one. So we had some other issues, due process wise, for example, issues relating to the presentation of witnesses and evidence. And I see we have a question, but let's talk to this one topic and then I'll go to the question on the table. So my personally, and I'll let you two pipe in, but I've seen judges. So the question is, how much can a judge limit the evidence that's presented by the parties? And sometimes I've seen cases where they should have limited them, ages ago. They let the trials go on forever when they shouldn't. But other times I've seen judges seemingly arbitrarily shorten the presentation of evidence of witnesses to the point where there's no way that an attorney is be able to put on their case. They have 3 hours or even one day when they have 15 witnesses and they have to, truncate everything they're doing in order to put on something to get a decision, but then the judge is missing out on a lot of evidence that the judge should have heard.
So I've had some experience with that, both in terms of family law cases and child welfare cases. For example, we do these permanency planning hearings in child welfare cases, and that determines whether the goal is going to remain reunification or change to juvenile guardianship or even termination of parental rights. They're very important hearings. And I've seen courts say you've got half an hour for your hearing. It's like, how can we talk about the permanency goal for children in half an hour? Or when I used to be a prosecutor in a county that's going to go unnamed, the courts at that time would do these review hearings by just reading the reports and then asking for comment from attorneys. There's no proofs. And again, we're talking about permanency for families. We're talking about best interests of children, and we're not even allowed to put on evidence, apparently.
Wait, and the reports are prepared by caseworkers, like CPS
Reports
caseworkers?
Yes, reports that are prepared by CPS and foster care workers. So it can be some significant limitation on the ability of the parties to present any evidence at all when talking about issues as significant as what should be the permanency goal for children. And of course, family law cases, obviously it's a little different, but I've seen that as well. We're going to set set aside an hour for an off the record conversation to figure out what parenting time is going to look like until we can have a referee hearing in 3 months. So it is certainly an issue in family law as well.
Thank you. So the question on the table, and this is going back to a couple of comments ago when we were talking about I think with the therapist making recommendations about parenting time and custody. The question on the table is a counselor qualified to provide an expert opinion on parenting time. Is there any law to support that counselor could provide an expert opinion? My instinct, I'll let either one of you chime in, is that a counselor potentially could be qualified as an expert witness, maybe if they have the right qualifications and have the requisite amount of experience. But I don't know that I've seen a counselor testify as an expert witness. I've seen psychologists who've testified as expert witnesses about parenting time and whether it's harmful or not harmful to the child. Do either of you have any feedback on that issue?
Well, I think more often than not, the counselors are testifying as fact witnesses, and that they're providing insight into what the children's preferences are, or the basis of their preference. I'm not necessarily, I think a lot of times providing counselor testimony can be very problematic in a lot of ways. Counselors, in my opinion, can be misused and abused and, manipulated, for lack of a better word. But I don't really see very often that they're usually qualified as experts. I think it's more of a fact witness. And I would agree with what Josh said earlier, that unfortunately, a lot of the times the court is just relying solely on what the children want and not really considering all the other best interest factors when determining parenting time. And, that's unfortunate. And even teenage children are certainly not in a position to be able to bear the burden of choosing between their parents.
I've seen cases where counselors have been admitted as expert witnesses. Now, what I'll say is the judges in mid-Michigan have made it clear that they don't want the opinion on what parenting time should be from these counselors. They want to use these counselors as more or less fact witnesses to get information relevant to the best interest factors, with the court maintaining that they're the ones who have the final say on what the parenting time should be. And obviously that's a little inconsistent from what I said earlier about delegation, but when the court doesn't delegate, I have seen some of our local jurists, judges, and referees both say, we don't want to hear what their opinion on the parenting time schedule should be. That's our job. They're just here to help guide us toward what the schedule should be.
Got it. Well, I want to make sure we have a little bit of time reserved today so we can talk about how to raise these constitutional issues in our family law and child welfare cases. So I'm going to switch gears, even though we have a few topics that we did not get to, and I'm sure other people have thought of other various types of due process or constitutional violations. So Trish, do you have your best recommendation about how to put the issue before the judge to get a ruling, preferably to protect your client's constitutional rights?
Well, I think obviously, first and foremost, the objection, if you're facing a situation where an order is about to be entered without any findings, without the consideration of any evidence, of course, making an on-the-record objection is your first line of defense. But more often than that, that doesn't work. So I do think then that the appropriate avenue would be to file a motion for reconsideration and really brief the law for the judge, and hope that that brief in and of itself will let the judge know that, hey, perhaps I made a mistake here and that I need to reconsider what I did. Of course, filing an appeal is an avenue. It's a great avenue, but it can be it could take a long time. And there's a lot of damage that can be done while the appeal is pending. So to the extent you can actually get the issue before the trial court, remind the trial court that it has a duty to conduct an evidentiary hearing and consider and make findings and actually follow the guidelines of the Child Custody Act. That's, of course, always your best line of defense.
I agree with that. If you anticipate this could even potentially be an issue, make sure you brief it for the judge before the hearing, if possible, so that the judge has everything ahead of time. If it becomes an issue and you didn't anticipate it, then be prepared to argue it during that hearing. And when I say argue, I think generally you have to be very mindful of the personality and temperament and demeanor of your judge. There are some judges who are going to listen to you. There are other judges who might dismiss you offhand. So it's important to understand the judge you're in front of and how to best approach that judge with these issues. But I do think it's important to be prepared to argue, judge, you didn't follow the law at the hearing, so that the judge is on notice and you're preserving the issue for appeal in case the judge doesn't get it right.
So I know, Trish, you mentioned the other day, making sure you ask for an evidentiary hearing. The problem I think I've seen is that a lot of those interim or temporary orders are done ex parte, without any kind of opportunity to even respond. And then when they're supposed to schedule the hearing within, 21 days, what I'm seeing are these hearings aren't happening within 21 days. They're just dragged out. So I don't know if you have any advice about how to actually, if you're dealing with an order where the judge is, doing something without the hearing that's required, what do you do to try to get a hearing instead of appealing? You'd much rather have the hearing, let the chips fall where they may, then you might appeal afterwards. Any thoughts about how to actually get that hearing?
That can be really challenging. And I have to say that if in fact it's looking as though you're not going to get a timely evidentiary hearing, then you probably are better off doing an emergency application for leave to appeal with immediate consideration, because I don't know that there's much you can do to really force a judge to give you a hearing if they're not giving you a prompt hearing date. But perhaps filing an emergency appeal would get the attention. And then, of course, you have to hope that the Court of Appeals would believe that it's an emergency at that point in time. But I think that's what you have to do, because I think the delays inherent in establishing a new custodial environment or having no contact between a parent and child, the damage can be so severe that I think at that point you have to do everything you can. And if it means filing an emergency application, then it should be done.
I think you also sometimes have to get a little creative. Let's say you've got issues A and B. Issue B is the custody issue with the interim order. File a motion on issue A and raise issue B within that motion. That might be a way to try to get it in front of the judge. The judge might very well say, we're not dealing with issue B, but at least it's some creative mechanism to try to get in front of them. And maybe you can get that addressed before the time that that it would have taken to do an appeal.
So I've seen or had situations where clearly the judge didn't follow the law, and I was, hired by the other side, the side that won in the trial court for the appeal. And so I felt in this one particular case that I'm thinking of, where the judge made a decision without any findings or evidence and just changed custody on a temporary basis without following the law, I made the decision to concede that the judge didn't follow the law. And so then it went back to the trial court to make the appropriate findings. Let's talk a little bit about the trial court, about a party, whether it's you or the other side, conceding when the judge is not following the law, so that things can be corrected more quickly.
I always do it. If I see a judge isn't following the law, or I see that I have an argument that it can't possibly win, I will concede it, because I don't think it's ethical to argue something that is contrary to the law if you know it's contrary to the law.
And I would agree with that. And I think in terms of, what it means to your client, yes, perhaps you're winning in the aspect that in the sense that you got the results you wanted. But if the results you wanted was the result of the judge not following the law, then you have to look to your client and say, but the other side could appeal, and then you're looking at a lot more attorney fees and a long length of time to get this corrected. So why not do it right the first time? And I know that's hard to tell a client who is looking at you like, well, but I won, I got the result I wanted, but the results you wanted might not be, it might be right in the short term, but in the long term, it could be very costly if you have to defend an appeal that ultimately, is not going to win on appeal. So I do think that, to the extent that we can, we should try to, even if you're on the winning side, you should still be urging the court to follow the law. It's just a lot easier in the end that it be done the right way.
Right, agreed. You already talked about making an objection on the record, and then I've very often recommended doing some sort of short trial brief, or if there's an issue that you think the judge is going to have trouble with, or maybe has already made mistakes on, doing either a motion or some sort of trial brief if you have an evidentiary hearing. And any tips that you have on trial briefs are not like appellate briefs, and that's the thing. Like those trial judges do not have the time to read a 50-page brief like things we're putting into the Court of Appeals. But do you have any recommendations about how, like in a briefing format, how to get something before the judge? Whether or not they read it is out of your hands, I guess. But if you give them something that's this thick, the motion and hundreds of pages of documents, I'm going to tell you they're not going to read it.
Yeah, if I have to draft a trial brief, which we often do for, if we're going to have a divorce trial, yeah, you have to draft a trial brief. I try to keep them less than 10 pages and focus on the important stuff. And there's going to be plenty of stuff in there that's relevant but not important. And maybe I'll, just very briefly mention it, but it's the important issues where I'm going to say, this is an important issue. This is why. Here's the facts. Here's the law.
Almost like an executive summary, right?
Yeah,
of what you're actually going to put on with your case.
Yeah, it's almost more like a memo than an appellate brief.
Now, turning back to the child welfare context, you mentioned earlier, Josh, how the right to counsel is guaranteed by the United States Constitution, which implies the effective assistance of counsel, not just any old attorney, but somebody who's actually effectively representing the attorney. And so many times we see attorneys who are ineffective. Well, unlike the family law context, where your only remedy is to fire your attorney or to, sue for legal malpractice, which, is not a very good remedy either if the client really has been harmed by an attorney's conduct. In the child welfare context like the criminal context, you can raise ineffective assistance of counsel and raise that kind of constitutional challenge. Do you have any tips for the child welfare attorneys in the audience who might want to either prevent the effective assistance of counsel from being raised, or if they come onto the case late and they need to have it raised somehow and they want to know how to do it.
So yeah, I think that let's first start with you come on the case late. I have taken over for a number of attorneys on these cases where I looked at it and realized the other attorney probably was ineffective. And I'm still managed to get positive results from my clients because I wasn't ineffective and I advocated in a way that would fix the issues that had been raised, which you can do, I think, more easily in a child welfare case than in a custody case because of these requirements for the agency to offer reasonable efforts and for these 90-day review hearings. So I can step in and look at it and say, client, you're way behind the 8 ball, probably because your attorney didn't help you here. Here's what I need you to do, and here's how I'm going to support you in getting there. I'm going to get on the phone with CPS and the GAL and whoever I need to. And we just see a 180 in the case that was going downhill, move it forward by me doing my job.
Well, let me ask this, because it seems like it would be very different from the judge's perspective between a family law case and a child welfare case. So in the child welfare case, you come on and you see it's been totally screwed up and you bring it to the attention of the judge of X, Y, Z, these 5 things need to happen. I feel my instinct is that the judge in the child welfare case is going to be like, yeah, I think you're right. Let's just go do it. Versus in the family law case, I feel like a judge's, well, any kind of case that's not criminal or child welfare, the reaction of the judge is going to be like, it's not my problem that you had a bad attorney. You're stuck with what your attorney did, all the mistakes that your attorney did. I don't care. Like, I just don't have time to let you redo things because you have an attorney you're now complaining about, whether the attorney was bad or not. It's like clients complain about attorneys rightfully or wrongfully. But my instinct is that the family law judge is going to be like, what do you expect me to do about it? Trish, do you have any comments about that?
Well, I think that's true. Obviously child welfare is completely different. I don't have a lot of experience in that, but, you're right that, if a mistake is made by your counsel, the court is going to say, well, that was your attorney. That's who you hired. And there's not much you can do about that after the fact. So I think it's important for litigants to choose the right attorney that don't make those kind of mistakes, because they're hard to undo if not possible.
Right.
And I think that stems from just the desire for finality within family law cases. You've got your final order. We're not going to revisit that except for change in circumstances. So it's less backwards looking and more forward looking, what happened from that order forward, whereas the child welfare cases, they're so fluid. From the date the child is removed until either termination of rights or the date the child's returned, it's completely fluid. It can turn on a dime.
Well, Trish and Josh, thank you so much for your time, and thank you for everybody who attended today. Like I said, we will be circulating takeaways hopefully by the end of next week, but everybody's still playing catch up from the holidays and everything else. So if you don't see by the end of the next week, it'll probably be the week after. But in any event, I wanted to point out that next month's webinar, February 10th, from 2 to 3, is going to be on the Big C, kind of a review of what's been happening with the Big C process over the past 2 years. And then before we close, I just want to give Josh and Trish an opportunity. If you have any closing comments or recommendations for the attorneys who are watching this.
Well, Lisa, I just wanted to tell you happy birthday.
Yeah, I got rid of the balloon that was in my office. My staff brought all this stuff. Like, oh my gosh.
Yes, I had to tell you happy birthday.
Oh my
I
goodness.
think in closing, I think it's important for attorneys to make the arguments, even if it's it seems like a difficult argument. Don't be afraid to make the hard arguments, and don't be afraid to request an evidentiary hearing. Just you have to do it. We have to have a return to some greater due process in family law cases, in my opinion, because the long-term implications are very damaging if it's not done right from the beginning.
One thing that I think is important, and we didn't talk about this today, I think I said this when we were chatting the other day, anytime the judge doesn't follow the law, that's a due process violation to me.
Yeah.
So that's why it's so important to make sure the judges know the law and do everything you can to make sure they're following it, because when they don't follow the law, that's a violation of your client's due process.
One more thing I wanted to point out, and I meant to say something earlier. So I did mention my book, Kids Caught in the Middle, but I want to point out that I have a quote from both Trish and Josh in the book. I'm not going to exactly tell you where to find it. You can go find it yourselves, but it's awesome. The quotes are awesome from Trish and Josh. Trish is in the first chapter, which has to do with due process violations. And Josh is in chapter 12, which has to do with child welfare proceedings. So you can read a little bit more from them. And I can't, from the bottom of my heart, thank you so much for being with us today. And y'all have a great January 6th.
Thanks,
Okay,
Lisa.
Thanks, Lisa.
Thank you.